versus Bardos. And each side will have 15 minutes to present their arguments to the court. And the appellant may have up to 5 minutes for rebuttal.
Thank you, Your Honor. Good morning, and may it please the court. I would like to go ahead and reserve 3 minutes for rebuttal.
Thank you.
Attorney Chelsea Finney representing the appellant, Mr. David Bardos. This is a case where Mr. Bardos was convicted of an F5 violating a protection order, Ohio Revised Code 291926. We are here today on a insufficiency claim and a manifest weight claim, and I would like to start with the manifest weight claim. Mr. Bardos was, as I said, convicted of violating a protection order against the victim in this case, Mrs. Erin Doyle. We believe that this court, sitting as a 13th juror, could find that there was, that the jury went against the way they should have gone. There was evidence presented by Ms. Doyle that she believed that she saw David Bardos violating a protection order on 2 different occasions on the same day. The first occasion was at a stop-and-go gas station in Medina, where she stated that she saw Mr. Bardos, his van pull into the parking lot and he get out of the car. At that point, her boyfriend, Mr. Hygeni, who was also getting out of the car to go get a pack of cigarettes, she called him back into the van and they left the gas station. She reported that she saw him. Her testimony reported that she saw him. Mr. Hygeni, who was also there, did not testify that he saw Mr. Bardos at the gas station. There was also Sergeant Undercoffer, who I believe a couple days after the incident occurred, went to the gas station. He was the only person able to review the surveillance video at the gas station. He testifies that a black van did pull into the parking lot, that a man of similar height and build to Mr. Bardos was in the gas station, but Sergeant Undercoffer was not able to say for sure whether or not that person was Mr. Bardos. He also is not able to say for sure, even if that person is Mr. Bardos, whether or not he knew that Ms. Doyle was in the parking lot, which in order to violate a protection order, you would need to know that you're within the 500 feet of that person. And there was no testimony that either Mr. Bardos knew that Ms. Doyle was at the gas station or that that person actually was Mr. Bardos.
Well, she testified, did she not, that not only that he was there, but that he made eye contact with her just as he was about to enter the store. Is that correct?
That was her testimony, Your Honor, that she thought that she saw him and she thought that he made eye contact with her, but there's no corroborating evidence from anybody at that scene that Mr. Bardos actually was present at that gas station, either through the surveillance video or through the testimony of Mr. Bardos himself, or Mr. Hygeni, who was also there, was not able to testify that that was in fact Mr. Bardos at the gas station. The only testimony is...
He was legally blind.
He was legally blind, Your Honor, yes. He was.
Well, is for sufficiency, isn't her testimony enough to get over that hurdle at least? I mean, you don't have to have corroboration, but even if you did, the fact that the officer went to review the video and testified that there was a van that was similar to his and that the person that was observed fit his description. Isn't that corroboration? Where she says, I looked him in the face and he looked at me and it was him.
For sufficiency purposes, I believe that it probably would be, Your Honor.
But not for the weight.
I don't think for manifest weight that her testimony is enough to get over the manifest weight hurdle. I believe that there is other evidence that would support Mr. Bardos' position that he was not there that day, especially that given there's a lot of black vans driving around. I mean, no one was able to put a license plate on this van. The officer was not able to get a sufficient look at Mr. Bardos in the surveillance camera. I mean, Mr. Bardos is a pretty average looking man. I mean, he went in, grabbed a cup of coffee by the front door and left immediately. there's nothing there to say that it actually was Mr. Bardos there, other than her testimony that she saw him.
So, for purposes of manifest weight, is your argument that the jury lost its way, does it rest on their determination of identity, or the determination of mens rea, that he knew he was within 500 feet of her, or both?
It's both, Your Honor.
Okay.
I don't think that there was ever any testimony, again, other than Mrs. Doyle, throughout the whole case, that states that anybody else was able to verify that Mr. Bardos was in fact at those locations. There's also no evidence that says, and he says that he was not at those locations. He testified that he was at home playing video games the whole day. Even if he had...
He didn't have any corroborating?
He did not, Your Honor. The defense did not present any other evidence other than Mr. Bardos. But even if he was present in these locations, he had to have known that Ms. Doyle was going to be there as well. And I believe that Sergeant Undercover even stated that, it was possible he may not have known Ms. Doyle was at the gas station, given where both of their cars were parked, and given that Mr. Bardos went right into the gas station, grabbed a cup of coffee, and left. And she left immediately after she claims that she saw him.
Well, I guess what I'm wondering is, why would we even consider mens rea, because he testified it wasn't him?
He did, Your Honor, and that just, even if this court finds that for the first incident and altogether, that he was there, even though he is testifying, and he did testify that he
Because
was
it just
not.
seems like inconsistent. I
I'm
mean,
sorry?
this isn't a civil case, it
Correct.
seems inconsistent is what I'm trying to say. I wasn't there, and if I was there, I didn't know I was there.
And I don't,
Basically, I didn't mean to be there. I don't mean to make light of it, I'm just trying to understand, it doesn't quite make sense to me.
I understand that.
You know,
Your
you can
Honor.
argue inconsistently in a civil case, I'm just not sure. You can say, I shot him in self-defense, and if you find I didn't shoot him in self-defense, I wasn't there. You see what I'm getting at?
I do, Your Honor. The brunt of the argument, I guess, is that he just testified that he was not there, and that there was no corroborating testimony that specifically placed Mr. Bardos in either the gas station location or the incident that occurred later that night that I believe was at a nursing home. At the second incident, Ms. Doyle testified that as she was coming back from her Halloween party, a black van pulled behind her and essentially followed her to her apartment. She was not, if you look at her testimony, she was not alarmed during this van following her. Her testimony was that everyone drives black vans. I wasn't able to see the driver. I wasn't able to see a license plate. I was not alarmed as this van was driving forward. It's not until the point where they get to the nursing home and she says that the van kind of blocked her path of leaving that the street light shone onto him, and she said that she saw Mr. Bardos staring at her. Now again, Mr. Hygiene is also in the car at this point. He can see the makeout of the van, but is not able to verify, because of his eye condition, that Mr. Bardos was in the van. And again, Mr. Bardos testified that he was not in that location at all. So we believe that the jury, given the testimony of Ms. Doyle, of Mr. Hygiene, of Sergeant Undercover, and Mr. Bardos himself, that there was not enough corroborating evidence to verify that Mr. Bardos was in fact in those locations that Ms. Doyle claims that he was in.
How about the facts that, and I hope that I'm not getting this case confused with another one today, that when the police began their investigation, they reached out to him and he said that he would meet with them, which he was not required to, but apparently had to be arrested on the warrant of the indictment. What are we to make of that? Is that something that I think that the state argues could be considered as evidence of guilt?
Your Honor, I don't think that should be considered as evidence of guilt. If you look at Mr. Bardos' past record, he does have 2 prior convictions of violating a protection order against Ms. Doyle. And so to get a 3rd allegation, I think he got scared, which is why he did not report to the police. I don't think that he was running from anything that should insinuate that he was guilty by any means.
So it wasn't like it was evidence of flight that was presented at the trial?
No, Your Honor. He simply just did not show up for a meeting, and they had to issue a KPS for him. I think that Mr. Bardos, and if you look at his testimony, was afraid that this would happen, that false statements would be made against him, and so I think that is why he chose not to, why he told the police he would be there and then did not show up. But I think that's why. I think he got scared that something was happening and that his worst nightmare was kind of coming to life. But I do not think that should be considered evidence of guilt, because it is his right not to talk to the police in those instances as well. And again, we would just ask this court to, we're obviously asking for a remand on this case. Mr. Bardos would like another trial on this matter, because he does feel that the jury did wrongfully convict him, given that there was no evidence other than the actual victim's testimony that he was verified at those locations.
Counsel, you have 15 minutes.
Morning, Your Honors, and may it please the Court. My name is Vince Bellucci. I'm with the Medina County Prosecutor's Office. I'm an assistant prosecutor representing the appellee in this matter in the state of Ohio. Your Honors, in this matter, as you've just heard, the jury found Mr. Bardos guilty of felony version of violating a protection order. Felony, of course, resulting from, as we just heard, Mr. Bardos' 2 prior convictions of violating the same protection order against our same victim here. The victim being the mother of his children, Erin Doyle. The only assignments of error in this matter, Your Honors, challenge the sufficiency and the weight of the evidence, and I think we just heard a concession from Mr. Bardos' counsel that there is sufficient evidence in this matter, but I will address that as well, even though that was their first assignment of error. With regard to sufficiency, Mr. Bardos first claims that it sounds two-pronged to me, and as Judge Carr pointed out, they're inconsistent arguments. First, he claims that...
I didn't say they were inconsistent. I said an argument could be made. I just always like to clarify that, because I just want counsel to know I'm just asking questions, and I want to see what their viewpoint is on it.
Okay. So the arguments were basically that, and first of all, I would point out that the mens rea here is not knowledge either. We've been talking about what Mr. Bardos knew or did not know. The standard under the relevant statute here of violating a protection order, the mens rea is not knowledge, it's actually recklessness. 2919-27. It says, no person shall recklessly violate the terms of a protection order. There was no dispute in this case that the protection order said Bardos was not permitted to be within 500 feet of Ms. Doyle, and that's the issue. Recklessly is defined by the Ohio Revised Code 2901-22C. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or be of a certain nature. I think Ms. Doyle's testimony here clearly establishes not only that Mr. Bardos was reckless, but that strongly also suggests that he knew exactly what he was doing on these 2 different events in the same day. So I'd just like to briefly go into what Ms. Doyle did testify to, and it was compelling. She described a course of conduct throughout 2 different portions of October 25th, 2014. First at 6 p.m., she stops at a gas station and looks over and sees a black van a few parking spots over from her, clearly within 500 feet of her. And the van she recognizes because it's a black Dodge Caravan. She knows that vehicle because she was in a prior relationship with Mr. Bardos and knew that he drove that vehicle. She looked over and saw none other than Mr. Bardos sitting in the front seat, looking over at her and made eye contact, as was discussed earlier. She thinks, okay, maybe that's just a coincidence that he's also here for some reason, and that's why she doesn't call the police at that time.
Did she testify that she thought it was maybe a coincidence, or did she equivocate that she didn't know for sure that it was him? She thought it was him, but she...
No, she absolutely 100% knew it was him. She just wasn't sure, you know, it's kind of a small town, maybe we just happened to be at the same gas station. That's the reason she didn't call the police at that time. She was also on her way to her friend's party, and I think she just kind of wanted to get on with her day at that point, which she did. She then proceeded with her fiance, who, as was mentioned, is legally blind, was legally blind. She proceeded with him and her 2 children to this party at her friend's house, and they leave the friend's house around 10 o'clock p.m. As they're coming home on Route 42 in Medina, a black van pulls behind her vehicle, and not just behind her, but right behind her, as in tailgating her, right on her bumper. That was the testimony. And the idea that she somehow was not alarmed, that's simply belied by Ms. Doyle's entire testimony. She was extremely alarmed by this situation and by the fact that this person was tailgating her right behind her. She described it as too close for comfort. She knew she was being followed fairly quickly at that point, and when she was being followed through intersections, through a substantial distance, and eventually all the way to her home, to the street where her home was located. And at that point, she was so frightened that she didn't want Mr. Bardos to know where she lived, so she kept driving right past her home. And she keeps going on this Springbrook Drive, where she lives. And she ultimately pulls into a nursing home complex. And Mr. Bardos actually then pulls into the last driveway before the nursing home, and is kind of just sitting there. Then she pulls back out, Ms. Doyle pulls back out, tries to head back down the road, back toward her apartment. And what does Mr. Bardos do? Well, he pulls out quickly into the street in his black van, blocking the entire street. She has to slam on her brakes and ends up about 20 feet away from him, she testifies. And it is 10 o'clock at night, obviously, but she testifies her headlights are shining directly at him now. And she gets a very good look at Mr. Bardos' face. This is Mr. Bardos. She has no question whatsoever that it's Mr. Bardos. Then, thinking on his feet, her fiance pulls out his phone and pretends to be making a phone call. And at that point, Mr. Bardos puts his van into gear and speeds away. And I should say also she recognizes the same black Dodge Caravan. Not only did she ID Mr. Bardos once again, but she ID'd his vehicle once again. So when Mr. Bardos questions whether Ms. Doyle could see him in the dark from 20 feet away, it's contained in the sufficiency portion of the brief, but that really is a manifest weight argument that he's making there, whether she can see him in the dark 20 feet away. Well, the answer is clear. It's one word: headlights. The headlights are clearly illuminating him and his features, and he's clearly identified by her. Now, I'm not going to spend too much time on sufficiency, but we know that requires this court to take Ms. Doyle's testimony as true and determine whether any rational trier of fact could have found the elements of the crime proven beyond a reasonable doubt. That clearly can be done here, and I believe we had a concession that is the case here. I think, I mentioned recklessness versus knowledge. I think just to get that standard out there, but I think what we heard from Ms. Doyle in her testimony went way beyond from Mr. Bardos' part being reckless. That he did know exactly what he was doing in this case. I think it's also worth noting there was quite a bit made about the fact that there's no corroboration. Not that there would be any required for either a sufficiency challenge or a manifest weight challenge, but there was corroboration, and the corroboration is at this gas station, there's surveillance video that an officer reviewed, and it saw a van matching the exact description that Ms. Doyle gave to the officers, this black Dodge Caravan. And it saw a man whose physical characteristics were consistent with Ms. Doyle's description of Mr. Bardos. That's what he said. That is what the officer testified to. Did he say 100% for sure this was Mr. Bardos? No, he said this man matched his physical characteristics and his vehicle. In any event, like I said, we don't need corroboration. The testimony of a single witness can sustain a conviction. And Ms. Doyle's testimony clearly was, if believed, was sufficient. I will move just briefly to manifest weight also. And that's obviously where this court can weigh the evidence, consider the credibility of the witnesses, the famous language, whether the jury lost its way and created a manifest miscarriage of justice. That is absolutely not what happened here. This is not one of those exceptional cases where the evidence weighs heavily against the conviction. The evidence weighed heavily in favor of the conviction. The trier of fact here, it was mentioned that Mr. Bardos testified. The jury here chose to believe Ms. Doyle's testimony over Mr. Bardos' testimony, which it had the right to do. And credibility determinations are left to the trier of fact, as this court has often stated. This court has held that the trier of fact is free to believe all, part, or none of the testimony of each witness, and that the trier of fact has the right to place considerable weight on the testimony of the victim, who in this case was Ms. Doyle. And when the jury can choose between the state's version of events, which was that Mr. Bardos was here twice and violated his protection order on this date, or that he was at home playing video games, the defendant's version of the events, conviction is not against the manifest weight of the evidence simply because the trier of fact chose to believe the state's version of events over the defendant's version of events. So the state of Ohio would respectfully request that this court affirm the judgment of the trial court.
Thank you.
Thank you.
You have about 3 minutes.
Thank you, Your Honor. Again, we would just like to state on Mr. Bardos' behalf that we believe that there wasn't a miscarriage of justice here, and that the jury did take the evidence in a way that it shouldn't have. We believe that there was not enough evidence here to have convicted Mr. Bardos of violating a protection order based on the fact that it essentially came down to Mrs. Doyle's word versus Mr. Bardos' word. And while we understand that the jury in this case is able and did make a determination on who they thought was a more credible person, we believe that given the other evidence that was presented to the court through Mr. Bardos' testimony, through Sergeant Undercoffer, Sergeant Lyons, and Mr. Hygiene, that there was simply not enough evidence to prove that Mr. Bardo was indeed reckless in his actions. And so that is why we are asking this court to remand this case and send it back to Medina